Okay, I'd like to call this meeting of the Ottawa County Board of Commissioners back to order. Today we are here for mediation, so I have a motion prepared. I move to go into closed session pursuant to MCL 15.268E to consult with corporate counsel regarding settlement strategy in connection with Hambly v. Ottawa County, because an open meeting would have a detrimental financial effect on the litigation or settlement position of the county. Could I get a second?
Second.
All right, thank you. Any discussion before a roll call vote? Let's go to a roll call.
Mr. Belknap,
Yes.
Mrs. Curran,
Yes.
Ms. Cosby,
Yes.
Mr. Bonema, Mrs. Rhodey,
Yes.
Mr. Zylstra,
Yes.
Mrs. Wenzel,
Yes.
Mrs. Miedema,
Yes.
Mrs. Ebel,
Yes.
Mr. Bergman,
Yes.
Mr. Moss.
Yes.
Motion passes.
All right, great. We'll go into closed session. Thanks. Okay, we're back in session. Out of closed session. So welcome, everybody. Have just a few things here to do. One is going to be to read a motion, have the board consider it, have a short statement, and we'll go from there. I move to approve a stipulation and order to dismiss in the Adeline Hambly v. Ottawa County matter as follows. It is hereby stipulated and agreed by and between the parties as follows. 1, Ottawa County hereby agrees to dismiss with prejudice all charges against plaintiff and dismiss the MCL 4611N removal hearing. Further, the charges raised cannot form the basis of any future future charges or discipline against plaintiff. Number 2, plaintiff hereby dismisses with prejudice all claims that were brought or could have been brought in this action against all defendants, Ottawa County Commissioners, and the county. Number 3, plaintiff releases all claims for damages of any kind, including but not limited to exemplary and punitive damages, with the exception of the issue of attorney's fees. Number 4, as to the issue of attorney fees, the court will decide the amount, if any, of attorney fees to be awarded. Such attorney fees may include any attorney fees in this matter, including from the removal hearing. Attorney fees shall be determined by this court at a time and date to be scheduled by the court. 5, the parties agree to waive any and all appellate rights in this matter, and defendants agree to withdraw their appeal to the Michigan Supreme Court in this matter. 6, the parties do not concede or admit that with respect to each other, they have violated any law, statute, ordinance, or contract, and or have failed in any duty or obligation whatsoever, and or have committed any tort or engaged in any kind of wrongful conduct. The parties specifically deny that they have engaged in any such conduct. The parties enter into this agreement solely in the interest of avoiding additional costs that would result from further litigation. Further, the parties acknowledge that the consideration described in this agreement is adequate and sufficient and represents a full and complete settlement of any claims and or rights. 7, the parties and their agents, attorneys, and representatives hereby forever and fully mutually release each other and their representatives, attorneys, employees, affiliates, subsidiaries, successors, and from any and all actions, causes of actions, suits, debts, losses, damages, claims, demands, or other liability or relief, whether in law or in equity of any kind, which occurred or existed as of the date of this stipulation. 8, in the event the county brings future charges under MCL 4611N against plaintiff on or before January 7, 2025, the parties hereby stipulate and agree that such charges will be decided through a public binding arbitration panel that complies with the Open Meetings Act, MCL 15261, and MCL 4611N. The arbitration panel shall consist of 3 members, 1 selected by plaintiff, 1 selected by the county, and a 3rd neutral arbitrator who shall be Thomas Beam. The arbitration panel shall comply with the rules and procedures of the American Arbitration Association. The arbitration panel's decision shall be binding on the parties and shall not be subject to appeal. 9, until December 31, 2025, in the event plaintiff requires outside legal counsel to address a legal issue affecting the Ottawa County Department of Public Health, plaintiff shall notify Ottawa County Corporate Counsel. Plaintiff and Ottawa County Corporate Counsel shall select a mutually agreeable attorney. Under no circumstances shall the total cost of the outside legal counsel exceed $1,000 per month. This stipulation resolves all claims and closes the case after the court issues an order resolving the attorney fee issue. Is there a second?
Second.
Any discussion? All right, seeing none, let's go to a roll call vote.
Ms. Cosby.
Yes.
Mr. Bergman.
Yes.
Mr. Zylstra.
Yes.
Mr. Bonema.
Yes.
Mrs. Wenzel.
Yes.
Mrs. Miedema.
Yes.
Mrs. Curran.
Yes.
Mrs. Ebel.
Yes.
Mr. Belknap.
Yes.
Mrs. Rohde.
Yes.
Mr. Moss.
Yes.
Motion passes.
All right, thank you. The only other thing we need to do is recess the meeting. So I move to recess this meeting at the call of the chair.
Second.
All in favor, please say aye.
Aye.
All opposed? That motion carried. And I'd like to thank the board for all the work today and all the hours put in. Thank you very much. We'll see you soon.
Mediator as well.
And thank Tom as well. Greatly appreciate it.